The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Well, Mr. McDonald, are you ready?
Thank you very much. If it please the court, David McDonald on behalf of the plaintiff's appellant. This case is a tragic example of the circumstances that happen when our social contract is completely broken down and Mr. Price was living in the dystopia that resulted of drug dependency, poverty, desperation. He was picked up on a minor charge, admitted to the jail, underwent.
Would you please speak up? Get that microphone as close as possible.
Is that better?
Thanks.
Is this better?
It's better, yeah.
Okay.
That's good.
Thank you. He was admitted to the jail. He was picked up with used and unused bundles of heroin. He disclosed that he was a heroin addict, and he had 10 bundles a day, which is a large amount of heroin and a severe addiction. All of the expert witnesses in this case have agreed that opioid addiction is a medical issue. It is not a moral failing or a character defect, and that he was inappropriately in the jail at Granville County because he was going to go through detox and withdrawal while he was there based on his history and based on their knowledge.
How many defendants did you join in this case?
Oh, well, we named everybody on the grounds that.
Give me the number of defendants that you sued.
I didn't count them up. There probably were
What?
15.
15?
Maybe, yes.
You sued everybody that worked at the jail, didn't you?
Well, we had a problem with the statute of limitations, and there is a principle for the bystander liability. We've abandoned that.
So could you help me then, just because the defendants argue that you've forfeited many of your claims against many of the defendants, could you just clarify for me what claims are before us now?
Yes, Your Honor.
Which claims against which defendants?
Right. I think that our Monell claim is the strongest claim that we have. We also have a
The
strong.
Monell claim against the county,
Yes.
so they had a policy of some kind in place that
They-
resulted in this tragic situation?
Well, the evidence of that is not sufficient. This policy is required by North Carolina law to be signed and reviewed annually.
I'm still confused about why it was necessary to sue 15 defendants, and 8 of them you don't even discuss in your brief.
We've abandoned that, Your Honor.
What?
We've abandoned those claims, Your Honor. We're concentrating on the Monell claim and of the 3 officers who were there and the sheriff.
Well, on the face of the brief, you got, all of them are named. They're appellees, defendants appellees. But everybody worked at the jail.
That's correct. But we didn't bring those assignments forward. The trial
But
judge
you
dismissed
accused them
them.
of being involved in.
Well, the trial judge dismissed them.
In killing this fellow,
The trial.
basically.
Well, we're
I
bringing.
just have a real problem with the way this case was litigated and saving 15 defendants, many of whom were not, were not involved, only tangentially involved, and they're not discussed here on appeal. And then some of them are just, it's just odd. Mr. Carter, for example, who provided aid and medications when you say it, you admit it's a compassionate act, and yet he still gets sued. The man actually provided aid in a very timely fashion, but he still gets sued, even if it's admitted that his involvement was purely a compassionate one. And there's just the net, there ought to be some cognizance of the fact that the net is spread so wide, you bring all sorts of people under into court, you cause them the anxiety and inconvenience of being named in a suit which they had an incident which they had nothing to do with, and which they tried to ameliorate. And I just have a problem with that, with litigating a suit in that fashion.
Mr. Carter was not trained in what to do. And instead of doing what he should have done, which was to call for a nurse to evaluate Mr. Price, he took it on himself to find some kind of preparation.
Was he deliberately indifferent?
Yes.
Trying to provide medication is deliberate indifference?
Well, because he's not qualified to make a determination what kind of medication he should have.
You may think that, but of course, if he hadn't provided the medication, you would say, well, he was right around there. He could have provided something. He could have provided some assistance. He didn't. But the standard is whether he was deliberately indifferent. And, whether you use an objective test or a subjective test, the deliberate indifference standard has not been repealed. And this man, whatever he was, he may have been mistaken, I don't know, but he was anything but indifferent.
Well, what he did do is he provided medication that caused him to vomit immediately. And it made the situation worse. So he made it worse, not better. Even though he acted out of compassion, he recognized that there was a need here, a medical need. And he took an inappropriate action. And the reason that he took the inappropriate action was that he was not trained. And the county's own expert witness said that the reason that Mr. Price should not have been in that jail is that there was not one single person there trained to deal with the problem, with the medical problem that he had. And that is a Monell violation.
On the Monell front, can I ask you, the defendants say that it is, the defendant's characterization is that based on this record, it is undisputed that there were no opioid-related deaths in this detention facility between 2012 and the time of Mr. Price's death. Do you dispute that?
We don't dispute that, but that I don't think
Well, isn't that pretty relevant to the Monell claim? I mean, I agree it's not dispositive, but it's at least relevant to a Monell claim, right?
Should be considered. And I think that the court needs to recognize that there were two different problems here. One was withdrawal and detoxification that took place for hours and hours and hours. Then there was the additional problem that somehow he got fentanyl in the jail. And the expert witnesses both say that he had to have gotten it in the jail. The sheriff said that he couldn't keep drugs out of his jail, and the sheriff didn't do anything about it. After he found out that Mr. Price had died because of fentanyl poisoning, he didn't even open an investigation.
This is a lot of hindsight and trying to string up people who tried to make the best of a bad situation.
Well, the time that he had been admitted to this jail earlier, they took him to the hospital, they had him evaluated by the medical personnel at the hospital, and he survived. This time, the expert witnesses both say that he should have been medically supervised the entire time, and that if he had been medically supervised, then the likelihood is that he would not have died. That is objectively unreasonable to put him in that situation for the withdrawal and detoxification, and to put him in a place where he might have access to fentanyl that would kill him.
So can I ask you about the declarations of the cellmates that you submitted? My perception is that some of the things in those declarations to me appear to be blatantly contradicted by the video, and I want to give you a chance to respond. So one of the things those declarations say is that officers ignored the cellmate's call request. That would be concerning. But then I look at the video and I see that every time there's a call request, a couple minutes later, someone shows up on the video. So I don't know how that can be squared with the claim they ignored call requests when it appears that in response to call requests, people came. What do I do with that?
Your Honor, what they say is that when they made these call requests, they called, they pushed the intercom, made a call, and said he needs medical attention.
And
They
then someone
came in,
and then someone shows up.
but these people are not trained and not
But
qualified.
I would okay, but again, maybe they didn't do the right thing, maybe they didn't do the good enough thing, but I don't think it's fair to say that when you make a call and then someone comes, that they ignored the call request. That doesn't seem like a plausible meaning of the word ignored.
It didn't lead to him having medical care that he needed.
Well, their line is that there is the video evidence, and the video evidence may not show every second, but the video evidence does not show, as far as I can see, it may not have a continuous picture of it all, but there was nothing in the video that alerted them, that would have alerted them to this situation. And the district court took a clear account of the video evidence, and it showed nothing that would have nothing that would have alerted them to a situation that they then were indifferent to or ignored.
Dr. McCoy testified that when Carter gave him the medication and he vomited, that information itself was not enough to ascertain whether he needed Narcan for an overdose or whether he needed something else for withdrawal. And that the difference was the difference
Well, if it had
between
shown
life
some
and death.
dire
And those,
information, if it had shown some dire information, that would have been one thing, but it didn't.
well, they said that if he had been medically monitored, then the doctors would have been able to put enough of the evidence together that a layperson with no training is incapable of making the determinations as to how to deal with the detoxification, not the death in the courthouse.
The response here was when the gravity of the situation became apparent, the response was timely.
At the time that any response
They were there.
occurred, it was too late.
They were there a couple of minutes.
But it was already too late at that point. They had notice from the other inmates, and this is very clear. They said, you got to get him some help. This is what the other inmates said, that they called, they said, this man is
How
screaming.
can people that, after the seizure, how can people that are on the scene a minute or two later be deliberately indifferent to someone's plight?
Because they were told about this by the other inmates hours before that happened. And there was plenty of time to get him the medical care that he needed. And they didn't do it. But they certainly were on notice because the other inmates asked them to get him medical care, according to their testimony. Now, the sheriff, there's an issue there about the sheriff. Now, the sheriff told the family when he advised them that he knew that Mr. Price was intoxicated when he was admitted and that he couldn't keep drugs out of his jail. Now, those things show that he had personal involvement in this case. Now, this is the same sheriff who was convicted of crimes related to the administration of his office, including falsification of documentation and inappropriate supervision of his drug task force. Now, I think that we've got a claim against the sheriff for deliberate indifference.
Thank you, Counsel.
And my time is up for now.
We're fine. Thank you.
May I reserve?
May it please the court, my name is Brian Castro. I represent the defendants appellees in this case. As this court mentioned, there were 17 named defendants. 13 of those were individuals. Of those 13, only 3 are even mentioned in the brief subsequently. We agree that the appropriate process would have been through the amendment process, through discovery. If one finds notice of an additional defendant that was actually involved in an incident, they can amend a complaint, not name all 13 at the outset.
Now, to give them some grace, that if they sued up against the statute of limitations, that's going to have potential relation back problems, right?
Correct, but if it arises out of the same transaction or occurrence, which would be the December 2018 incident, then it would potentially meet the Rule 5C standard.
Well, it wouldn't just be that, they'd have to have notice.
Right.
The true defendant would have had to have notice within the limitations period, right?
Correct, within the one, yes, exactly. The question before this court is whether the district court in its 51-page, well-thought-out opinion correctly ruled that the individual defendants were entitled to qualified immunity, that they did not violate any constitutional rights of the decedent, and that no policy...
It's interesting that you mentioned the 51-page opinion.
Exactly.
I don't think we can judge these things purely by length, but on the other hand, part of our duty as an appeals court is to make sure that district courts don't just dust these things off or give them the back of the hand. And when somebody writes a careful opinion, 51 pages, goes through each and everything, he did the kind of job with this that we expect our district judges to do. There was no, dusting off or deflection or giving it the back of the hand. Now, I'm not saying that that's dispositive, but what I am saying is that it's something that a court of appeals can take note of, whether a district court was careful, or whether a district court was, in a hurry and didn't much care. But I think when a district court goes to the lengths that this district court did in discussing this claim, that's worth something. That's worth something in the way that the process is supposed to work.
Absolutely, we agree, and it's indicative of the thorough process that the judge engaged in at the district court level. Of course, this court's analysis on appeal is de novo, but it is worth considering that the chief judge carefully analyzed all the record evidence, including the affidavit submitted by the plaintiffs and the video footage, which, as you all mentioned, is clear and undisputed, and it shows the interactions of the decedent. It shows how he was acting hours before the incident.
So, but can I ask you about the probably the thing that troubles me the most about this? So, Limerick didn't subject Price to the withdrawal protocol because she determined he was not exhibiting symptoms of an opioid overdose. That seems to me to contradict the declarations of at least some of the cellmates who say it was, quote, obvious that he was high. That's JA 1340. How do I square her statement that he was not exhibiting signs with them saying it is obvious he's high?
Well, firstly, you can square that by reviewing the footage. I believe it was Deputy Harrison that was the arresting officer, and it clearly depicts Price. And you can, first of all...
But we're not talking about the arrest. We're talking about when he's in the detention facility. They're saying he's obvious he's high.
Right. They're saying that he's obviously high after he's already in the booking process, already in the detention center, in the detention facility, not during the inmate booking process. And there's no evidence that anyone perceived him in that state. That would be how you would square that, because...
But actually, okay, so he's arrested, he's then brought in, he's processed, and then he's placed in the holding cell. That's the sequence of events, right?
Exactly. He's processed by Limerick.
Right.
And as the plaintiff has conceded and admitted, on a previous occasion, you can also consider that Limerick also conducted the intake and booking process of Price. And on that occasion, she did perceive that he was exhibiting severe withdrawal symptoms, and she did, in accordance with the policy, not allow him to be admitted. The plaintiff concedes this in the brief. You cannot argue that a detention facility, on the one hand, does not have appropriate policies, but then argue that on a previous occasion, when that detention officer, it's their duty upon intake and admittance to visually observe the inmate, conduct the preliminary screening and the questionnaire, and make a determination of whether this person can or cannot be admitted.
What about the fact that Limerick wrote on the intake form that he was on 10 bags a day? Doesn't that mean she obviously knows that he's a drug user?
That means
A regular, frequent, significant drug user, not just a drug user in the abstract.
Correct. She knows, and it can be undisputed, and it does not lead to any liability, and we admit that he was a drug user, or that he did have a drug problem. However, the question before the court is whether he was exhibiting a serious medical need. This would be,
But doesn't it seem really obvious that someone who is a heavy user of opioids, who is then involuntarily forced to go cold turkey, is going to have withdrawal symptoms? Doesn't that seem, well, obvious?
It may seem obvious, but the level of the symptoms and the severity of the medical issue is what the court can also focus on, because there are, of course, mild withdrawal symptoms. There are many in the jail context. You would expect on a weekend, let's say, someone is drunk, publicly intoxicated. They're admitted into the jail and they're placed in a holding cell and they're withdrawing. However, is it a serious medical need? Is it the shakes? Is he sweating? Is he vomiting? Is he exhibiting convulsions? And that is not what happened here. The video evidence shows that he's walking around, he's showering, speaking to the other inmates, and acting normally. And the plaintiff's expert admitted to all of this in the deposition and stated, he seems to be fine to me. The throwing up doesn't
When you
indicate.
take those words, the standard is a serious medical need.
Exactly.
And that's, that's not anything. And the manifestation of a serious medical need began when he started convulsing. And that was what put them on notice. And then within minutes, people arrived and tried to do the best thing they could for this gentleman. And so the quickness of the response when they were put on, it was the convulsions that put them on notice. You look at that video, or you read the record here, and there may have been some intoxication or whatever, but in terms of a serious medical need, it was the convulsion that indicated that, yes, the medical need was not just some run-of-the-mill intoxication, which is true of a lot of jails. People come into a jail very often in an intoxicated state, because that's why they've been misbehaving, and that's why they're brought into the jail. But being intoxicated is not invariably indicative of a serious medical need, but convulsing is indicative of a very serious medical condition that needs prompt attention. And this, they could not have come on the scene any faster than they did.
Correct. And the plaintiff's own expert stated that this was one of the fastest reaction times he'd ever seen. It was less than a minute. It was about 50 seconds from the time that he begins exhibiting. Of course, it's important, as Your Honor mentioned, when is there notice of a serious medical need? It's not when he's exhibiting mild withdrawal symptoms. It's not when he's walking around and engaging in conversation and acting normally. It's when the inmates notice that he's convulsing. It's depicted on camera. They immediately press the button. The officers come in. Within 1 minute, they come in and respond, and then EMS is called, and EMS arrives within 5 minutes of the scene. So this cannot be said to be deliberate indifference. If the
Can I ask you
plaintiff,
just about the protocol, not about what happened here? I just want to understand what the policy is. When does the protocol say that you're supposed to trigger the withdrawal protocol? What is the thing that is supposed to trigger the withdrawal protocol under the policy?
I would have to look at it. I believe it's section 2.02 or 2.03 of the policy, but it is when they're exhibiting symptoms of severe intoxication or withdrawal is when you...
Severe is the...
Yes.
You think of, I understand that...
It would have to be something of the sort of they're in need of additional medical attention.
Can I follow up on the question I asked you earlier about Limerick? Doesn't one of the declarations, this is J 1340, say that he was obviously high when he was admitted?
I would have to look back at it might be the Ferguson affidavit, I'm not sure, but no.
I don't have it in front, I don't know the name,
Yeah.
it's
No.
J 1340, I believe it's, that declaration says he was obviously high when he was arrested and when he was admitted.
Yes, but even if the court is to take that into account and,
Well, don't we have to at summary judgment?
well, you have to unless it's blatantly contradicted by the record, including the body camera footage of Price when he was arrested 30 minutes or so before he was booked. You have to look at that and say, how does he actually look? Does he look like he's obviously high? Secondarily, if someone is high, that's a subjective term in and of itself. Obviously high, is it a serious medical need?
I guess not everyone who's obviously high is going to experience severe withdrawal.
Exactly. Not all of them are going to exhibit a serious medical emergency requiring emergency attention by a further action. And the record here, including the video, shows that he's not showing himself to be obviously high or obviously intoxicated. He's not stumbling around. He's not exhibiting any actions that would back up that statement in the declaration that he is actually obviously high. The court ruled in favor of the defendants on multiple grounds. It analyzed Short in detail, each factor, which was the standard enunciated in 2023, but it also noted that Short was not clearly established in December 2018 when this conduct occurred. So this court can affirm the judgment of the district court under either standard, even if, but Short has been met here, so that's irrelevant. But even if it had not been met, the court can still uphold the district court's decision based on qualified immunity.
The policy here, which cleared through state law, it has an emergency plan, a first aid training, substance abuse, it addresses substance abuse services for inmates. I don't think you need a policy. You can have a policy statement that covers all forms of substance abuse. I don't think it would be a requirement that you have a separate policy statement for this drug or that drug, or one policy statement for opioids and another policy statement for fentanyl and whatever. In other words, I think it, as far as I can tell, that it's a fair enough thing to have a comprehensive policy that covers all forms of substance abuse, because the symptoms can be a little bit different, but also many of the symptoms overlap. And so I think it makes sense to cover treatment for substance abuse comprehensively.
Yes. If you look at the case law, it would even allow for a more general policy than what the detention center has here, one that would actually cover the situation where you're seeing someone who's exhibiting intoxication. Some detention centers even have lesser comprehensive policies. You don't need to have one that's specific to a specific drug or substance. But here, they do account for intoxicated individuals. They do account for withdrawing individuals. So they have implemented and they have a policy in place. And as the judge mentioned, there have been, the plaintiff has not forecast any evidence that there's a policy, practice, or widespread custom at the jail of allowing these types of individuals to go untreated. Or since 2012, there have been no deaths. And again, they admitted that in a previous occasion, this policy was used to help Price. So there is no dispute regarding the fact that the detention center has a policy and that they've even used it with the specific decedent here. Additionally, regarding the sheriff's statement that no one can keep all drugs out of a jail, that's not enough to
Is
forecast.
we have some of these jail cases, and some of them are quite horrible, in terms of their neglect to the point of deliberate indifference. And the conditions there are bad, and they lead to deliberate indifference. But as jails go, this one was pretty darn good. It has a policy and a detailed policy in place. This is the first time that this is the first incident of this sort that has occurred, and not only was the policy in place, but these people responded within minutes to the most obvious manifestation of a serious medical event, which was the convulsing. And the standard that we are left with is a deliberate, not only deliberate indifference, but deliberate indifference to a serious medical need, which was not manifested. And when you read the record and you read the district court's careful exposition of this case, they were not on notice of a serious medical need, and then to which they just sort of turned a cold shoulder. Now, as I say, if you try to look at the universe of jails, this one is a whole lot better than many of the really alarming situations that we see in some jails. I wish most jails had these kinds of policies, and that most jails would respond as quickly as this one did. We'd be a lot better off, because there are a lot of jails that don't. And the situation is bad, and the response time lags, and sad consequences ensue. But this is not that case.
Correct. And that is why this is an appropriate summary judgment case, because we don't need a jury. There are no genuine disputes of material fact regarding this response time. It's on the record, and it's clear. The issue of notice, when did they have notice? You see it on camera. You see them respond quickly. Regarding the policies and practices, this is not a situation where a jail is ignoring someone who is in obvious need of help.
How do you get access to the fentanyl in the jail?
There's been no determination of how that occurred.
But both the experts seem to agree that it must have happened there in the jail.
Both of the experts agree that he must have taken the substance while he was at the jail. There's nothing on the record regarding how he obtained it. It is clear on the record that he was frisk searched. He was asked to squat and cough and all the other processes.
Did the experts speculate as to how he did?
They don't.
Is there any circumstantial evidence as to how it happened? I mean, what's the?
There is no
So
circumstance.
how do we take that in light most favorable to him? What's the best way to look at that?
The best way to look at that is that the plaintiff
The
has.
proper way to look at it, I should say.
The plaintiff has not established any record evidence whatsoever regarding how he obtained the drugs. There was no.
It's unknown how.
There's
how he
nothing.
obtained the drug, but under the expert testimony, it had to be taken. Timing of it means it had to be taken while he was there.
It had to be taken while he was there. We don't know whether he obtained
Where
it.
is Granville County?
It is about an hour from the center of North Carolina, about an hour from Raleigh.
What's the county seat?
I'd have to check that, I'm sorry.
It's on a map, right?
Yeah. it's
Yeah.
on the map.
Well, neither one of us are from North Carolina. But anyway, it's in the Eastern District, we know that, but I didn't know.
Yeah.
Somebody else may know that here.
Yeah, so apologize for that, but the plaintiff did not establish anything regarding how this was obtained. In another case, for example, let's say a counter situation where the plaintiff had somehow.
But we have to look at the facts in the light most favorable to his side.
Well, in the
So
light.
what is it, what do we take it in the light that way?
Well, he took the drugs while he was in jail. That seems to be pretty well established, but that doesn't establish a policy that they allow drugs in the jail.
I'm
Yeah.
not arguing about policy, I'm trying to I'm interested in the fact.
Right.
That it doesn't appear I couldn't find it in the record, and I thought maybe you could help me out, but.
Yep, there is nothing on the record regarding how he obtained the drugs, to answer your
And
question.
there's no speculation as to how he traded.
No speculation, nothing.
Nobody has speculated. Okay.
The only speculations that have occurred have been regarding when he would have, not speculations, but the expert testimony of George Heim, which is a forensic toxicologist, who opined that he had taken the drugs at or near the time of the incident, which is relevant to the whole claim about the severe withdrawals. The evidence regarding the drugs and how they were obtained and when they were obtained are simply that he took them while he was there, at or near the time
And
that
if he, right, and if he had it, it was missed in a search of him.
correct.
It was in his pocket or something.
If he had it, it would have,
He shouldn't have had access to it from any source other than himself, certainly.
Yeah,
He
it-
shouldn't, and he shouldn't have had access to it from himself.
exactly, and they searched him, so that's undisputed. They searched him and they followed that protocol, so it wouldn't be in the light most favorable for the plaintiff that they just let him in with a drug and didn't do anything about it. It would be that somehow it got in and somehow he was able to take it at or near the time of the incident, leading to the sudden convulsions. So it wasn't a death by with a severe withdrawal, it wasn't death due to the withdrawal symptoms or anything of that nature. It was fentanyl toxicity on that morning that caused the severe convulsions, which led to his death, which is relevant to the notice issue. The fact that they didn't have any notice that this would occur on that morning in the sudden fashion that it occurred due to the amount. And that's the expert testimony of George Heim. I believe my
All right,
time is
thank you.
expired.
Let me ask my co-panelists if they have further questions. Bob,
Fine.
you okay? Okay. We're okay, thank you.
Thank you.
You have some rebuttal time.
I've got to address the policies, Your Honor. The policies that they have submitted to the court provide that the medical plan must be reviewed and signed by the sheriff, the Granville County Health Director, and the chairman of the Granville County Board of Commissioners annually. They have produced none of these. What they have produced instead is a draft policy that is unsigned by anyone, that is dated 2020, more than a year after this incident occurred. There is nothing that shows that they complied with the North Carolina requirement, that they have these policies, that they put them in writing, they signed them by all of the people, and they update them so that they are current to reflect the current medical knowledge. And medical knowledge changes all the time. Now, they didn't do that. What they have produced for you and all of their testimony relates to these unsigned draft policies. That's a violation of North Carolina law, and I don't see how this court can say that they get past summary judgment on deliberate indifference when they have not complied with the North Carolina state law. We asked for this in the discovery, and they
Wait,
didn't
hasn't
produce
the
it.
Supreme Court said that failure to comply with policies or with state law is insufficient to show a constitutional violation, that those are separate questions? If they violated North Carolina state law, you might have sued against them for violating North Carolina state law, but that doesn't mean they violated the Eighth Amendment, right?
That might be true.
I mean, the Supreme Court has literally said that, haven't they?
That might be true, but what it indicates is that they have not done what the North Carolina legislature has
Sure,
required
and then
them
maybe
to
you
do,
can- maybe you
which
can
is to meet annually to update this policy with the medical director. In that meeting, the medical director and the sheriff would have met to say, we've got to meet again to update our policy, anything going on. The medical guy is going to say, well, there's medically assisted treatment. It's a program that has been adopted in more than half of the jurisdictions of the United States, is cost-effective, and it saves lives. And you ought to
follow
consider
on
that.
What Judge Heighton says, if we were to somehow lump and equate some sort of policy violation with a constitutional violation, which the Supreme Court has said do not do, because that would discourage states and localities from adopting policies in the first place. And you want them to adopt policies, you want them to have policies like this one in place. And and the Supreme Court says if that equates to a constitutional violation, that's going to discourage localities from taking the initiative to
There is,
develop policies. Those policies are a good thing.
there is no evidence in the record that they ever adopted a policy. The evidence in the record only refers to a draft that occurred more than a year after all of these things occurred. And if they had complied with the law, this would have been signed, those meetings would have occurred, and they would have produced it for the court to consider. And the reason that this matters is that if they had been up to date, then they would have known that there was an opioid epidemic that was declared by the president, and that they were going to be in the crosshairs, and that they needed to make preparations to have medical treatment when they had inmates come in, and that everyone that had this problem needed to be screened by a qualified medical person. And they did not do this. And this is what caused these injuries. It is direct, and it is a direct Monell violation. It is inadequate training, and it's long been recognized as a Monell violation. And if they're entitled to qualified immunity, the officers are, because they were not trained to recognize the symptoms and to act at an appropriate time, and that the only time that they could be called upon to act is when the man was already in the final throes of death, then that's an inadequate policy, Your Honor.
You seem to be ignoring the fact that you have the burden of proof as far as inadequate training and this and that. And I don't see that you've carried that burden in anything like something that creates an issue of triable fact here.
The opinion of the defendant's own expert witness saying that no one in the jail was trained to recognize these symptoms or to deal with this problem, and that this was the reason why it happened, and if they had had someone there, then he wouldn't have died. I think that's a prima facie case.
All right, thank you, sir.
Thank you very much, Your Honor.
We will come down and greet counsel, and then we'll move into our second case. All right, come on up and let's hear from Mr. Prestera.
Prestera, yes.
Yes, we'd be happy to hear from you, sir.
May it please the court, Brian Persteri here on behalf of Captain Gardenia Dorado Ocasio. This case comes down to a Administrative Procedure Act claim against the Department of the Army Board of Correction and Military Records on arriving at a decision to deny relief to Captain Dorado Ocasio upon appeal of an evaluation report that she received and then subsequently appealed to the board. It comes to the court on cross motions for summary judgment, obviously granting the motion in favor of the government and arriving here today on de novo review. The issue before the court is fairly limited at this point, and
If you move your microphone over a little in this direction, you might be better. There you go. Okay.
okay.
Thank you very much.
Yes, Your Honor. The issue in this before the court today is actually fairly limited, and I think it really boils down to whether the Administrative Procedure Act is now being treated as essentially a factual sufficiency analysis as it relates to boards of correction and review from the U.S. military. And so I say that because when you look at this court's precedent in the Downey case, and I understand it's an unpublished decision, I say the word
So
precedent.
before we get to that, can I just ask you something that is bothering the heck out of me and I'd like to give you a chance to respond to?
Yes, sir.
Why in the world didn't you submit the AR-15 to the ABCMR? This feels like the whole case is like vastly more complicated and confusing because the AR-15 is not part of the administrative record.
The 15-6 investigation, Your
Sure,
Honor?
the 15 yeah. The investigation, the thing that's not part of the record, the thing that the initial decision maker concluded was the reason for doing all these things.
Yes, Your Honor. So I can't speak to the reason that it wasn't submitted to the ABCMR. I was not counsel at the ABCMR.
I mean, one hypothesis I have is that it maybe looks really bad for your client. I
Well-
mean, I don't know what to do with it. Like, there was an initial report, and it's not in the administrative record, and you're the one who compiled the administrative record. And one hypothesis that arises is that it explains in fulsome detail. But I don't know because it's not in the administrative record.
No, Your Honor, and we know that that's not actually the case, and so I can explain that.
Okay.
The 15-6 investigation is into, the reference 15-6 investigation is not into the accusation of reprisal. I think you're talking about the AR 15-6 investigation that's into the underlying misconduct allegations against Captain Dorado Ocasio
Exactly.
that resulted in her OER
Exactly.
evaluation.
I believe that's right, too.
Yes, and so what was submitted and what was presented was the allegations of an inappropriate relationship existed and were substantiated essentially against her, but unsubstantiated against the other half of that relationship. The male officer, who's a major that she was alleged to have the inappropriate relationship with.
How many rounds of review has this case already been through?
At the Army level, in the agency, it was 2. It was appealed to the,
Well, I mean, there was a senior reviewer in the military, and then there was an Army specialized review, and then there was a civilian board of corrections for corrections review, and then there was a district court review. You've been through all these different levels of review, and none of them, whether they be military or civilian, has found in your favor, correct?
that's correct, Your Honor. And so what I would say to that, however,
What
is,
you want is to strike a effectiveness report.
well, the evaluation, the officer evaluation,
yeah.
yes.
Efficiency report, whatever you call them. The acronym. I call them the effectiveness report.
Yes, Your
I was
Honor.
in the military myself, so that's what we called them back then. But there have been review after review, and by AR-15, you mean the Army Regulation
That-
15. There's a thing in the military code of justice called Article 15. You weren't talking about that, were you? That's a-
No, Your Honor.
that's a- That's
There's
a punishment situation.
That's correct. There's no Article.
You weren't talking about Article 15s.
That's correct. We're
That's
talking
a-
about Army Regulation 15.
That's the most common thing in the military that has a 15 to it, I think, Article 15.
I'd respectfully disagree. I think actually that the AR-15-6 investigations are actually causing more of an issue these days, but that's not an issue.
No, I'm not arguing about that.
Yeah.
I want to identify that you're not talking about the Uniform Code of Military Justice, Article 15.
That is correct. I'm not talking about Article 15.
That's a type of punishment.
That's correct. We're talking, when we say, and AR is obviously administrative record as well, we're talking about Army Regulation 15-6, which is for administrative investigations within the United States
And again,
Army.
so the question why that AR 15-6 investigative decision was not submitted to the final military decision maker is why? Or what you were speculating why it might have been?
Yes, Your Honor. There's, one of the reasons may have been that the appellant didn't have a copy of the investigation at the time. I mean, there's any number of
Does
reasons.
she allege that?
No, there's no explanation in the record that I'm aware of as why the document was not presented at the time to the Board of
Can I take
Corrections.
you to a different question? So one of the things that you fault the body that we're reviewing that has that long acronym, you know what I'm talking about, the final pre-district court decision maker, right?
Yes, Your Honor.
Okay. One of the things you fault them for is not responding to your client's double standard argument, that she was treated one way and someone else was treated another way, right? Could you show me where in the administrative record it establishes that that argument was ever made to the board?
To the Board of Corrections?
The final Army decision maker. I couldn't find in the administrative record anywhere that was obvious that the double standard. So you, in your brief to us, you fault the final Army decision maker for not addressing the double standard argument. It's not immediately obvious to me from the administrative record where a double standard argument was ever made to the board.
Your Honor, I'd have to go back and actually look in the appeal to the Army Board of Corrections.
But I mean, the board doesn't have to respond to arguments people don't make to the board, right?
That's correct. It does need to present a rational decision process that it went through in its
Sure.
articulated
But
decision.
if you're going to fault an administrative agency for not responding to an argument, don't you have to show that you made that argument to the agency?
Yes, Your Honor, and I believe that argument was made to the agency. I can certainly look for that reference. I don't have it off the top of my head to be able to provide to the court. But I would agree with you that the agency cannot be faulted for not deciding something it's not presented with, certainly. That issue was never even brought up before the district court, however, upon the summary judgment.
Our precedent indicates that we should be exceedingly reluctant to inject ourselves into review of individual officers or enlisted man performance. And I think there are all kinds of reasons for that. One reason would be that there must be thousands upon thousands of efficiency reports that are written. And without some deference to the people who draft those efficiency reports, if we tried to make ourselves an active agent in this whole chain of command, we would be overrun. So there's the question of the volume of it. And there's also, but that's not the sole reason. The other reason is that the supervising officers, both by virtue of their military training generally, and also by their knowledge of the particular individual, are far more conversant with the facts and circumstances in military context than we are. And what we are being asked to do is to essentially inject ourselves into the middle of the chain of command and become drafters of an efficiency report, in effect. And that seems to me to be something that our precedent and Supreme Court precedent has said that that is a step we should take only with the greatest of caution.
Well, Your Honor, I disagree with you on both points that you just made there, and I'll take them directly, but in actually reverse order there. Regarding the court being asked to inject itself into the rating scheme process, that is not what we're asking the court to do. What we're asking the court to do
Well, sure you are. You're asking us not to accept the evaluation that the superior officers made.
At this juncture, what we're asking the court to do is hold the Army Board of Corrections to the standard of articulating a proper rational decision in the case. I'm not suggesting that there is no manner in which the Board of Corrections could still deny relief with a properly articulated decision on these facts. Rather, the Board of Corrections must be held to the standard of the U.S. Supreme Court and this court to provide that articulated decision. And that brings me to my point about the precedent. There is a very high level of deference articulated by the Supreme Court and this court. We acknowledge that high level of deference, but it is not zero review standard. And it says that the court still must articulate a satisfactory, the board, the agency, must still articulate a satisfactory explanation for its action, including, quote, a rational connection between the facts found and the choice made, and end quote. And that's from
Well,
Downey, but citing,
It seems to me that that was done here, because the complaint that you have is essentially, the assignment of error is essentially against Lieutenant Colonel Holloway. And you say that he had a conflict of interest, and that the conflict wasn't explained, but that was taken up. And what Mr. Holloway did was what Colonel Holloway did was absolutely what Colonel Holloway should have done, which was to tell the plaintiffs to stop retaliating against those who were critical of her, and that's a sound kind of decision. No, don't react defensively. Don't retaliate against people who are critical of your performance. And then that would seem to me, that's the concern about retaliation is something that not only the military might think worthwhile, but we ourselves have innumerable policies which are anti-retaliation policies, and then Colonel Holloway was referencing those.
of course, Your Honor, and I don't fault him for that. I fault him for then doing exactly what he told her not to do himself. And that is when he was under investigation, as a subject of an investigation by her, a valid complaint that was being investigated, he then took adverse action against her, exactly as he admonished her not to do.
He was her commanding officer, right?
I'm sorry, sir?
So can you point me, I understand that your argument is that in an ideal world, he shouldn't have done this, but can you point me to any Army regulation or other rule that requires rating officials to recuse themselves in this kind of situation?
No, I'm not aware of any rule that
So
requires.
you're not alleging you violated any rule by being involved? I mean, wasn't he required to do this given the role he had?
He was required, in a manner of speaking, to rate those that he's responsible for rating. However, there is a process to remove or replace a rating official if that becomes necessary during the course of the evaluation drafting period following the period following the rating period. The regulation goes through a whole process and a number of reasons that can occur. There's various reasons that can occur. And so regarding that, I think that the primary issue for this court at this point, especially in light of the two cases that we've identified, is less on the factual issues in this case, because again, we were seeking a remand to actually get a properly reasoned decision from the Board of Corrections in the matter. The issue before the court is really what is the standard that the lower court must uphold under the Supreme Court precedent from Bowman, and as well as this court's own precedent. And is this court going to?
But you seem, the bottom line is that you are wanting some version of the federal rules of civil procedure to govern these kinds of officer efficiency reports. These are simply different environments. The military one is simply, it's a world, it's not a world apart, but there are different sets of standards and everything, and to apply summary judgment standards and saying, is there a dispute of material fact here, or who bears the burden and everything, that seems to me to be contrary to our decision, which has indicated that, and they go through, and it says, it's very different from when we have in reviewing a sentencing decision, where we say, you've got to address this and that and this and that. And the decision, the standard of review here is quite different, because we explicitly say that we're not reviewing whether the OER went point by point by point. You just have to have a discernible line of decision. And I can figure out why.
No, you can't, Your Honor, respectfully.
Yes, I can.
You can figure out possibly why. You can figure out a possible explanation, as the lower court had to scour the record, as I've said in my brief, to find facts to try and supplant on behalf of the Board of Corrections, because the Board of Corrections did not actually assert any reasoning itself, and that's what the problem is here.
What about this line at J20? The applicant has not shown the evaluations rendered by the rating officials represented anything other than their objective judgment and considered opinions at the time the contested evaluation was prepared, or that they exercised faulty judgment in evaluating her as they did. That sounds like a rationale for rejecting her claim.
That to me sounds like a conclusory statement, and I think that's exactly what the court in Williams v. Roth, as we've cited, was getting at, is these conclusory statements of, trust us, we've reviewed everything, there's no error here.
Not we reviewed anything. Part of your argument is they exercised faulty judgment or their inconsistent standards, and it said it's not just that, right? The report also says we reviewed the following materials. There's a long list that said we read this, we read this, we read this, we read everything you submitted. You're not alleging they didn't read something they were supposed to have read. And they said, based on everything we've read, you haven't shown that the officers, because again, I mean, like, our job is not to make the officer, my sense is this board's job is not to say, we're gonna decide anew whether they should have done this. We're gonna decide whether they sort of transgressed the rules in making their decision. And we conclude this appears to be their judgment, and it's reasonable, and the judgment is, I mean, yes, could they have said more? Absolutely. 100% they could have said more, but it seems fairly discernible to me why they rejected this claim.
No, I guess I just respectfully disagree, Your Honor, because I think that the conclusion that they have rejected it because they don't think the evidence meets the standard, that they've articulated, but they haven't articulated why, and they haven't articulated anything about the conflict of interest that was
I
present in the
don't
case.
see any limiting principle to this. This strikes me as the kinds of claims and the kind of assignment of error that could be raised in any kind of evaluative situation. I don't see the limiting principle, but perhaps you can tell me one when you come for rebuttal, okay?
Yes, Your Honor. Thank you.
Let me, Rob, do you have any questions?
I'm good.
We're fine, thank you.
Thank you, Your Honor.
Good morning, Your Honor. May it please the court. My name is Carolyn Wisnowski, Assistant United States Attorney representing the Secretary. At issue is whether the district court correctly upheld the decision of the Army Board for the Correction of Military Records, which for everyone's convenience, I'm going to call the board, under well-established and deferential standards of APA review to not remove an officer evaluation report, or OER, from the plaintiff's military record. Now, plaintiff does not challenge the district court's holding that the board's decision was supported by substantial evidence. Instead, her sole claim on appeal is that the board did not adequately explain its reasoning for denying plaintiff's request. As plaintiff concedes, the board was required only to examine the relevant data and provide a rational connection between the facts and the decision it made. As this court has held and settled principles of APA review tell us, an agency's explanation need not be a model of analytic precision. Rather, the board's decision only has to be clear enough that the agency's path may be reasonably discerned. Even a cursory review of the board's opinion reveals the path the board took. After summarizing all of the plaintiff's arguments and evidence, as well as the facts in the record it found relevant, The board stated that it found the OER to be procedurally and substantively accurate and the product of the objective judgment and considered opinions of plaintiff's rating officials. In short, the board was not persuaded by any of plaintiff's arguments or evidence, including her primary claim that her rating official, Lieutenant Colonel Holloway, was biased or conflicted against her.
Are we the fourth or fifth body to review this matter? I mean,
We would be Your Honors, you would be the fourth because we have the Army Special Review Board, the ABCMR, the District Court, and then yourselves. But I would also note that the AR-15-6 investigation at the heart of this matter also went through several layers of review. I believe it was reviewed by a major general and then a brigadier general who approved the reprimand against the plaintiff and then supported Lieutenant Colonel Holloway's decision or recommendation that she be removed from command.
Can
Now-
you point me to anything in the board's decision that responds to the plaintiff's argument that the investigation she started against Holloway posed a conflict of interest that should have prevented him from issuing the OER?
So, Your Honor, I was taking a look at plaintiff's brief to the ABCMR as well as the ABCMR decision itself, and it does not appear that the plaintiff made that argument to the board.
Okay, but that's a different argument. They didn't have to respond to it because she didn't make it. But you agree they don't, in so many words or even kind of glancingly, they don't really respond to an argument like that, right? When I get to the board's decision, I don't see, and that's not a problem because.
No, you don't see that level of explanation. However, I would argue that that is covered by the board's rationale in its decision that the OER was created following substantive and procedural regulations. Because as of course plaintiff conceded, there is no Army regulation that says that if a subordinate officer raises allegations against her rating official that he need be removed. And I would also.
Well, there's no regulation that says he always has to be removed. But one could certainly imagine situations in which any reasonable observer would conclude that someone should not be reviewing someone else's work, right? We could imagine situations where.
Absolutely, Your Honor. I don't think that is the case here if you're looking at the underlying facts. I think what you'll see is that Lieutenant Colonel Holloway began counseling the plaintiff for her behavior of retaliating against subordinates right when he became her rating official, well before the plaintiff ever raised any allegations against him. And those continued, and there's evidence in the record of those counselings and why he was making those, and that's very well documented. And I think, Your Honor, can also be assuaged by the fact that the OER itself was also reviewed by another her senior rating official, and that's Colonel Porter. And
He's a senior rater. I counted
Yes.
these things up. I thought that he was number 6.
Of levels of review, yes.
There's a rater, there's a senior rater, there's the Armory Special Review Board, there's something called the ABCMR, which operates with 3 judge panels, or 3-member panels. And that's number 4, I think. And then, is there anything after that before it gets to the district court?
No, Your Honor, goes
And the
from.
district court's the 5th. And
Yes,
we're the 6th.
If we're counting the rater and the senior rater, then that's 6 levels of review.
The level of review, well, if you don't count the rater, it's the 5th.
Then that would be 5th, yes, Your
But-
Honor.
But the rater starts it out. It rates the officer.
Yes, Your Honor.
Every officer has a rating officer, right?
Yes, and in most
Way the military
cases,
works.
a senior rating official.
we've been over and over and over this. It's been massaged and re-massaged and examined and re-examined and everything, and there has been, at no previous stop, has there been a problem with the review that took place here. And I don't see any limiting principle to this. I mean, there may be a disputed issue of fact, there may be a disputed issue of a conflict of interest and everything, but that's going to be almost a commonplace charge if we recognize this claim in any situation in which the officer efficiency report or the efficiency report is written by a supervising officer, the claim can be made, well, the supervising officer didn't like me, or the supervising officer was a friend of my enemy, or whatever, and therefore there's a conflict of interest, and you cut into the chain of command by having conflict of interest claims brought against superior reviewing officers when the reviewing officer is supposed to have a familiarity with the facts and everything that you don't have when the decision maker is operating in a civil environment. You invariably have a reviewing officer who knows a lot about the individual, who knows a lot about the unit, who knows, and you can point out conflicts of interest. Oh, this person had it in for me. Every unfavorable efficiency report. Well, this person was out to do me in. Here's a conflict of interest. I mean, that is there's no end to this.
Yes, yes,
I
Your
don't
Honor.
understand why we should be doing something that 4 or 5, in my judgment, levels of review have said no.
Yes, Your Honor, I agree, and I would point out also that plaintiff brings no complaints or allegations of bias against her senior rating official, Colonel Porter, who I believe had also served as her original rater in a prior period. And I think plaintiff also fails to explain how it's biased for Lieutenant Colonel Holloway to report in her officer evaluation report the factual findings of the Army investigation on her OER. And those are not Lieutenant Colonel Holloway's own opinions. That's the result of an independent Army investigation. And Army regulations allow for the inclusion of derogatory information in an OER if it's the result of a completed AR-15 and 15-6 investigation. And again, I think Your Honor is correct that.
Allowing all of these claims to go forward and everything, we are undercutting in a basic way the military chain of command. And we're sort of encouraging those whose performance are being reviewed to take issue with the reviewer, and this could happen time and time and time again, and you really cut into the chain of command in the military, potentially, if these claims start rolling along, because every unfavorable OER, the person who is reviewed unfavorably has every incentive and indication to think this was unfair. I mean, whenever we meet up with a disappointment in a career path or in this or that application that is rejected, most people think it's unfair. They have a higher opinion of their abilities than someone else does. But in a military context, you just can't let that go on a roll.
Yes, Your Honor, I agree, and I think that's why other panels of this court, for example, in REAP, have noted that that is why the court should apply an extremely extra deferential standard of review when we're looking at these military boards of review decisions, because there's this recognition that
Because the APA tells us to? Where does that come from?
I believe that the Fourth Circuit has taken that.
No, I'm just curious.
oh.
I know we've said it. I'm just curious, like, because the APA says to?
I think it's a recognition of the difference between, yes, it does derive from the APA. I think that's also something that has been injected into this court and other courts about the way we treat the military because of its sort of special status as a very complex organization with its own set of governing rules, and the idea that it is best suited, like other agencies, to make its own decisions about its own personnel and applying its own regulations. And that's something that also comes up a lot in DC Circuit cases. they see quite a few more ABCMR appeals than the Fourth Circuit does. So I think McKinney, which we cited in our briefs, explains that point. I would also,
And all this started in Iraq, didn't it?
yeah, yes, Your Honor.
Was at the time, I think it's 2019, was it considered a war zone at the time?
I know that plaintiff was deployed in support of Operation Inherent Resolve. I am not personally familiar, and neither does the record state, about whether or not that was a war zone.
But to amplify.
But she was on deployment.
Judge Wilkinson, that's even more reason that we don't want to be involved in what happens, or is going to happen, or has happened in combat zone.
Yes, Your Honor, I agree.
The chain of command makes a heck of a lot more in that situation, I would think. The first thing, that's like rule number one in the military, as I recall it, that was a long time ago. You need to understand the chain of command. And everybody does, or did.
Yes, Your Honor, and that's why the plaintiff here was counseled for when she violated or appeared to violate Lieutenant Colonel Holloway's commands to not engage in retaliatory behavior against her subordinate. Plaintiff also alleges that the district court substituted its own judgment for the panel's. I think that's not the case. The district court did spend a lot of pages explaining why plaintiff's arguments were wrong. But however, it did not deviate from the board's analysis itself. It merely expanded on those points. And also, the district court also had to evaluate whether or not the board's decision was upheld by substantial evidence. And given, as Your Honors have noted, the several gaping evidentiary holes in the case, that took a lot of filling in the facts.
I think at this point, I'm going to ask, we throw this open to questions, and if my co-panelists, we appreciate your argument, if my co-panelists have any questions of you, I'm going to ask them if they do, and do you have any questions, Bob?
Nothing further.
I do not.
We have no questions,
Okay.
further questions. Thank you.
Thank you,
very
Your
much.
Honors.
Mr. Prestero?
Thank you very much, Your Honor. Regarding the court's reference to a limiting principle and the concern that the court articulated about this opening a floodgate of some manner for evaluation appeals, that's just simply not the case here. This is a very limited type circumstance where there was an ongoing investigation by Captain Dorado Ocasio into the conduct and the treatment that she received from her raider, her primary raider, at the time that he took this action against her. And so it's a very unique set of circumstances that.
And that was Colonel
resulted.
Holloway.
That was Colonel Holloway, right. So she alleged that Colonel Holloway had improperly retaliated against her by giving her a reprimand because she reported a sexual assault on behalf of another soldier. And that matter was then investigated. During the course of the investigation into Lieutenant Colonel Holloway's conduct, he issued appellant this referred evaluation. And
So isn't that the double standard argument?
Yes, Your Honor.
So, and again, could you tell me where you've made this argument to the board?
Well, I think it's presented within the enclosures and the evidence that was
Where?
presented to the
Page
board.
number?
I'll get the page, I'll get the specific page
This
number
is on
in the joint
rebuttal.
appendix.
I thought,
Yeah,
okay. I'm a little confused why you don't have it right now, but sure.
Yes, Your Honor, I didn't write it down. I'm flipped to the page in the document. Her sworn statement, matter of fact, I actually do have the page number. Joint Appendix 55 to 59, Your Honor.
Thank you.
Yes, I'm sorry for
Nope,
my
nope.
delay on that response. So the limiting principle, I think, here is the very unique facts and circumstances of this case. This does not open the door to anything in terms of an increased volume of cases. All we're asking this court to do is maintain the standard that currently exists in the law for the agency to articulate any type of factual connection to its decision-making process, just as the district court did in this case. Again, we're not saying that the agency couldn't deny relief. We're saying that they didn't properly. And I'm out of time, but pending the court's questions. Thank you very much.
We'll come down and, Bob, is it okay if we move into the last case, or do you want to take a brief recess?
I need a break.
Pardon?
I need a break. I do need a break. Yes,
You want to take a recess?
yes.
We'll come down and greet council, and then we'll take a brief recess.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. Mr. Naley, is it? Neal, yes. Okay.
Thank you, Your Honor. May it please the court, I'm Edmund Neal. I'm counsel for the appellant Malik Wilder. Your Honors, this case is about lawful means. That's the fundamental requirement for an inevitable discovery. There's no question the warrantless search of Mr. Wilder's bag was unlawful. The firearm obtained from that unlawful search should have been suppressed under the exclusionary rule, but the district court declined to do so. It instead applied the inevitable discovery doctrine, which of course is an exception to the exclusionary rule. The district court ruled police would have inevitably discovered the firearm in the bag after arresting Mr. Wilder and conducting an inventory search.
And so just conceptually, there's two questions as I understand them. One is a factual, well, a counterfactual, right? But one is in the nature of a factual question. What would, in fact, the police have done, right? And then the second question is, if they had done that thing, would that thing have been lawful, right? Those are sort of the two questions. You agree?
Yes, Your Honor, that is the standard for inevitable discovery, yes.
Okay. And the district court found, as a factual matter, that they would have, in fact, done that thing, right?
Yes, Your Honor.
And that's a factual finding?
It's a factual finding
Reviewed for
about.
clear error?
Well, Your Honor, it's a factual finding about when Mr. Wilder was arrested, and that's in Sabron. It's a question of fact precisely when the arrest occurred. The actual conclusion.
That's a factual, I mean, that's a separate question. I don't tend to think that's a question of fact, but what the officers would have done strikes me as a classic factual finding to which an appellate court owes an enormous amount of deference to a trial court, right?
Yes, Your Honor.
Okay.
Now, that is true, and that's, Your Honor, of course, talking about the standard of review in this case. Now, I would note two things, and it's addressed in the brief. In the McCraw case from 1990 from this court, that if the district court clearly erred in finding somebody was lawfully arrested, that ruling can be reversed based on clear error. And in this case, Officer Chinani, the officer who unlawfully searched Mr. Wilder's bag, he testified no less than 6 times that he did not arrest Mr. Wilder until after he located, found, and retrieved the marijuana. He did not arrest Mr. Wilder based.
But can I ask why that matters? Because it seems to me that this court's decision, so your whole argument is like he wasn't arrested until a certain time, and because he wasn't arrested until a certain time, we can't do inevitable discovery. That just seems directly contrary to C, and I know that you say that in C, it didn't happen until after the person was arrested, except for the part when I literally go to our opinion in C and I look at page 223, where it says they were preparing to arrest her, as in it was before they actually arrested her. So any argument that as a matter of law, inevitable discovery doesn't work if the person wasn't already under arrest doesn't work because in C, the person wasn't under arrest when they did the search that we upheld under the inevitable discovery doctrine.
Well, Your Honor, actually in C, the officers did 2 things. They had gone into the hotel room where Devin Bracey.
I know, but preparing to arrest her is word for word from C.
Yes, they first determined they had a probable cause to arrest her, and then they determined they would arrest her. And while during the arrest preparation process, i.e. getting her in handcuffs, getting her out of the room, taking her to the jail, they conducted the search in that case. In that case, the officers clearly testified they were going to arrest her based on the drug paraphernalia that had been found in the room prior. It had nothing to do with what was found in that bag.
But here in this case, the district court found they were going to arrest. I mean, can I take a step back? I mean, admittedly, this is like another counterfactual. Can we agree that, so after your client admitted to having nothing but a little weed, if the officers literally at that moment said, you're under arrest, this case would not be here, right?
Your Honor, I would answer that question as saying it's not could the officer.
No,
arrested-
I know. It's a hypothetical. You're not conceding anything but this case, but just as a framing matter, if right after he said that, they had uttered the words, you are under arrest, this case is over.
If we had that in the video, yes, Your Honor.
No, I understand.
Yeah.
I'm not in any way suggesting that's what happened, but you agree that that is what happened. That would be over because it is in fact illegal to possess even a little bit of weed. So they would have had actual probable cause to arrest him, and if they said you were under arrest, we'd be done.
If that had been shown on the body camera video.
You're not conceding. I know you're not
I'm
conceding
not
that's what
conceding,
happened.
Your Honor.
I totally understand.
And if if Officer Chinani had testified, I would have arrested him at that precise moment, either that testimony
We
or on the
had
body
reason
camera.
to arrest him once he said that.
He could have arrested him,
That's
but
what- I thought that, yeah, could've.
he
would
would
be-
not have arrested him, though. That's the
Pardon?
key.
I thought you said he didn't arrest him then. He arrested him later, after he found the gun. But when he knew about the weed, he had probable cause to arrest. He told him, what is that? It's a little bit of weed. That's illegal.
And,
He
well, Your
later
Honor,
said he would have been arrested anyway because of the marijuana, but I thought the hypothetical, I thought you'd say yes to Judge Hyden.
well, I just wanted to make clear that I'm not conceding.
Those aren't the facts, though, but he could have arrested him, he would have.
If the officer testified, I would have arrested him based on that statement, we wouldn't be here.
I
But-
guess maybe take a step back to my framing questions, which were, there's two questions. What would the officer have done, and would it have been constitutionally permissible? So question one, question two. Once your client utters the words, nothing but a little bit of weed, the answer to question two is done, because they could arrest him at that point, right? The only question is if they would have. I agree with that. But I'm saying, once he says that, the question of whether the Fourth Amendment authorized his arrest is over, right?
Again, Your Honor, that is.
Whether it authorized it, not whether they would have done it, but whether the Fourth Amendment would have authorized it.
Would there have been probable cause? Is that
Yes.
what Your Honor's asking?
Yes. Once a person says to a police officer, what you are seeing protruding out of my satchel is weed, that officer can, not that they would, I take your point. Look, depending on where we are in the country, various times, I'm not saying every single person who has marijuana on them gets arrested. Officers constantly don't arrest people that they have reason to believe have marijuana on them. But the question is whether they could have done it. They certainly could have, right?
In another case, they could have, but in this case, the officer would not have arrested
Okay,
Mr. Wilder.
fine. So but that's the critical question. The question is what the officer would have done.
Yes, Your Honor, would, and not to repeat myself over and
Totally.
over, but it's would, and we cited a couple cases in the
I
brief.
thought he said he would have arrested him anyway.
He said he would have arrested him no matter what else he found, i.e.
Yeah,
after
he would have arrested him on the marijuana.
only after retrieving that bag from the bag.
I thought he said he would have. What about the bolo, whatever it's called? They got what do you call those things?
Oh, be on the lookout.
Be on the
Mis-
lookout. These people are considered, they're both convicted felons and should be considered armed and extremely dangerous. This defendant and his girlfriend, I guess, they're considered armed and extremely dangerous. Now, so that they weren't just normal law-abiding citizens that they were running, the policeman was running into.
Well, 2 points about that, Your Honor. Mr. Wilder was not in fact wanted. He was with Ms. Sinkler, who was the wanted individual in that bolo. And this case actually
No, it
started.
says both subjects, and this is bold language in the bolo, I got it here in front of me, are convicted felons and should be considered armed and extremely dangerous.
And that went to,
With
the original motion was actually based on a Terry argument. The government expressly disclaimed any reliance on a Terry frisk and asserted
No, but
search.
that's what the information they had at the time. They had this bolo when they found these two people. And that was the background of what transpired.
That's what initiated this investigative
That's
detention.
Exactly, right. And
Yes.
then they had that information, and then he asked him what that was sticking out of his, whatever, the bag, and he said it's just a little bit of weed.
And the officer did not arrest Mr. Wilder. He
He said he
searched that
didn't arrest
bag.
him, he said he did not arrest him, but he had that bolo information that this guy is considered armed and extremely dangerous.
Well, what I was saying was the government disclaimed any reliance on a Terry frisk. And number two, the
He
district
wasn't
court
a choir
found.
boy. He knew at that point, he had strong reason to believe he wasn't a choir boy.
Right, Your Honor, and the government argued search incident to arrest, and of course, the district court found that Mr. Wilder was secured and not within reaching distance under this court's decision in Davis, and the government has never disputed that finding. So the question is, did an unlawful search?
You know, I
Sir.
mean, it seems to me we're getting tangled up in could have, would have, this, and everything. I mean, it's got to be more straightforward than that. I don't see how we get around our precedent in C. But the three different events here. One is the arrest, and second is taking to the station house, and then third, I guess, is the inventory search. And those are the three things, and I wonder if C indicates that the precise chronology of these three things isn't really crucial. Where did the officers mess up here? I mean, they had probable cause to arrest with the, when he says there's just a little bit of weed, man. No, they didn't have to, as Judge Heitens points out, they didn't have to arrest, but they had probable cause to arrest. Okay, if you arrest someone, you can take them to the station house, and then an inventory search here, they have a form that they provide in terms of the items that should be checked for. And obviously, they have an inventory search for one simple reason, that the jail authorities want to keep drugs and weapons out of the jail. And so if the arrest is okay, if they take it to the station house is okay, and if the inventory search serves a perfectly legitimate purpose, I don't understand how the officers acted unlawfully, given our precedent in C.
Your Honor,
This argument is getting too tangled in, and I'm trying to discern just by getting down to the fundamentals of where there was a misstep here. I don't understand it.
Your Honor, the misstep was Officer Chinani testifying to a search incident to arrest, not testifying to any standard inventory search or any standardized criteria. The government expressly disclaiming that any inventory would need to be created and telling the district court there is no policy applicable to the facts of this case other than.
Well, but there is no search incident to arrest here. There didn't necessarily have to be a search and an incident to arrest under C. If he had the authority to arrest, he would have the authority to take an individual to the station house, and if they're going to be admitted into the jail, they have the authority to conduct an inventory search. In fact, they'd be foolish not to.
And again, just make sure we're clear about what C says. In C, Devin Bracey, the defendant's companion, was already going to be arrested for drug paraphernalia found in the room. In this case, Mr. Wilder is only arrested based on something that is unlawfully pulled out of his bag in violation of the Fourth Amendment. They're completely different factual circumstances. Mr. Wilder is never actually placed under arrest.
Why didn't this more analogous what the old Terry stop thing? The officers are entitled to protect themselves, and he was entitled to. He knew those people were armed, considered armed, and extremely dangerous, and he had this bag on him. And if he's going to be around him, he wanted to make sure there's no firearms in it.
Well, Your Honor, the government expressly disclaimed any reliance on Terry, and I think they had to in light of this court's decision in Buster.
Okay, I'm just throwing that out. I mean, why doesn't that dispose of it?
Well,
Any way you look at it, I don't think you got a leg to stand on, basically. The gun was proper, seized, and your guy pled guilty to it.
well, in Buster, the defendant was presently dangerous. That was, or in Buster, the key
There's
is.
different theories of upholding what happened, and several of them apply.
You were saying something about Buster.
Well, in Buster, the court pointed out that the defendant has to be presently dangerous, and in Buster, the defendant was not. In this case, Mr. Wilder was not. In analogous circumstances in
He
Davis.
had a loaded firearm in front of his body. And the BOLO says, consider him armed, he's a convicted felon, consider him armed and extremely dangerous.
Well,
And they knew it was him.
again, Your Honor, government did not raise Terry. They abandoned it expressly. And then search incident to
I'm
arrest.
raising it, I'm just telling you my reaction to the situation.
Well, I would just say that he was secured and not presently dangerous, handcuffed behind his back, and restrained by an officer, multiple officers actually, surrounded by officers, not within a reaching distance of that bag. In a different case maybe, but this is not that case.
All right, thank you.
Thank you, Your Honors.
Mr. Garner?
Thank you, and good morning, and may it please the court. Ben Garner on behalf of the United States.
So there was your opposing counsel argues that they should have done this, or they could have done this, or whatever, but does the case not bottom out on what they actually did and whether they took any kind of unlawful action?
Your Honor, in this case, the government relied upon the inevitable discovery doctrine in terms of the seizure of the firearm from Mr. Wilder's bag. There was testimony from Officer Shinani that he would have arrested Mr. Wilder.
So before we get to a note, just to confirm, the government has not been relying on a Terry frisk rationale, right?
That is correct, Your Honor. The government's position below was that there was probable cause to search Mr. Wilder's backpack and disclaimed any basis upon Terry. And instead, the government below relied upon a search incident to lawful arrest as well as the inevitable discovery doctrine. The district court found that Mr. Wilder would have been arrested even absent a search of Mr. Wilder's backpack, and that is ably supported by the
And that
testimony.
made sense.
Correct, Your
It
Honor.
wasn't the theory you offered, but that's the one you're offering now.
No, Your Honor, that was offered below in front of the district court as well, the inevitable discovery doctrine.
You made alternative arguments.
Yes, Your Honor. Search incident, lawful arrest, as well as inevitable discovery was pursued below. The
So
district
do we
court's...
think what happened here is that this police officer just got confused about the difference between an inventory search and a search incident to arrest?
Your Honor, I think that's certainly my reading of the transcript strongly suggests that. You can tell different portions. He was almost using the words interchangeably. The district court, who was there assessing the testimony, it noted in his order that the court believed that Officer Shinani was using the words interchangeably, noted that no magic words are necessary. However, the district court continued.
Which words was he using interchangeably?
Search incident to lawful arrest, as well as the
Inventory
search. Thank you. But the district court nevertheless methodically went through the testimony of Officer Shinani to conclude that that there was a standardized policy with the Myrtle Beach Police Department, and it based that finding on Officer Shinani's testimony, as well as the body camera footage of the other officers who, prior to transportation, Mr. Wilder's transportation.
So can I ask you, so the other thing that's confusing when I read this officer's testimony, whether this is clear error is a different question. But when I read what the officer says, it's like, what was the point at which it was inevitable he was going to be arrested? When I read the officer, old record, totally get, clear error, totally get. But when I just read it, it sounds like he's saying, when was he definitely going to get arrested? It's when I found the marijuana. It's like, well, but, and you agree with me, sorry. You can't rely on the finding of the marijuana to justify the search that produced the marijuana, right?
Agreed.
Okay, so help me out. It seems that he says over and over again, when was it inevitable he was being arrested? Once I found the weed.
Right, and so what I distinguish, Judge Heitens, is the portions of the testimony where Officer Shinani seems to be alluding to when he subjectively believed Mr. Wilder was arrested, when he was actually arrested, versus at what point would Officer Shinani have arrested Mr. Wilder?
What time, when I placed him under arrest versus when I decided to place him under arrest? Is that the idea?
Yes, Your Honor, and I think that the most clear portion of the transcript that supports the district court's finding is on page 76, when Officer Shinani made clear that he did not know there was marijuana, quote, until Mr. Wilder made the statement that there ain't nothing but a little bit of weed. And then immediately after that, Officer Shinani said, once I knew there was marijuana in the bag, he was going to be placed under arrest.
Now, does an officer is an officer compelled to conduct a search incident when you arrest with he didn't have a warrant in this case, he simply had the statement that it's just a little weed. An officer has probable cause to arrest in that situation, but then is an officer compelled to conduct a search incident? Or is an officer without authority is it either impermissible or is an officer compelled to do it? Or does an officer have the option of not conducting a search incident and taking the arrestee to the station house. Just tell me what, because the whole thing is confusing as to whether an officer is compelled to make a search incident once a warrantless arrest is effectuated, or is an officer allowed the option of taking the arrestee to the station house? Does an officer have that option?
He does, Your Honor. An officer is not compelled, either at Myrtle Beach specifically or an officer generally, is not compelled to execute or to conduct
You
any
don't
search.
have to conduct a search incident pursuant to the arrest, do you?
Correct, Your Honor.
All right, you can take the arrestee to the station house, can't you?
That is correct.
And you can conduct an inventory search here because of the obvious purpose of not having drugs in the facility and not having guns in the facility. It's a protection for the other inmates in addition to keeping track of property. In most places, most jails do. So have inventory searches. So the question I have is in terms of what was done here, the arrest was okay, there was probable cause. He could take it to the station house. He had that option as opposed to being compelled to conduct a search incident. And then they had the authority to conduct an inventory search. So if those three steps were valid, and Say seems to indicate that the order in which all this takes place is not crucial, where's the problem?
And the government contends to be sure that there is no problem. And to your point, in terms of the policy, Officer Shinani, during the suppression hearing, was specifically asked, what policy, if any, does your department have regarding searching someone prior to transporting him to jail? And he testified that according to the standardized policies at Myrtle Beach.
You don't have to as a matter of federal law, but I mean, I would think it might be good practice in many situations to conduct a search incident because you don't want someone riding around with you and everything with a gun. You would want to disarm the individual with a search incident. So I can see that having a search incident makes good sense, and not waiting for the inventory search to uncover the firearm. But the question of whether it makes good sense or not is a different question from whether there's a requirement under federal law that there be a search incident. And I don't think that requirement exists under federal law.
It doesn't, Your Honor. And to your point, not only would it be imprudent to allow an arrestee to have a firearm in the back of a patrol car, it makes less sense to allow an arrestee to have a firearm taken into the jail context. And that's precisely what Officer Shinani testified to in terms of the policy at the Myrtle Beach Police
Can I
Department.
take one step further, though, back?
Sure.
You would agree that just because an officer has probable cause, they don't have to arrest someone, right?
Absolutely.
You agree, in fact, we could probably take judicial notice of the fact that officers constantly have probable cause to believe people have committed arrestable offenses for which they don't arrest people.
Absolutely, Your Honor. And so as I read this court's decision in C, as well as the Ninth Circuit's decision in Peterson, for which the government submitted a 28J letter, is that the standard is that there's probable cause to arrest the subject. There's testimony or other evidence in the record that the officer would arrest the subject and that the subject would be bound for jail.
I would find it a frightening situation if we were to say that an officer that has probable cause to arrest, has to make an arrest. I guess you could, you think of, does that extend to jaywalking or does that extend to expectorating or whatever? I would say that particularly when you're talking about relatively minor crimes, and this one is relatively minor, the crime for which he was arrested. And I'm sure when he provided his confession, saying it's just a little weed, that he was relying on the fact that it was relatively innocuous and that the officer would just let it go. And in many cases, that would have been a good judgment on the arrestee's part. But, once you got to the jail, there was a good reason to say, this could be a real problem in terms of what my friend Judge King is pointing out, that you could have a person who's armed and dangerous, and you want to make darn sure that that person is not circulating among the detainee population.
Right, and this court has explicitly recognized that as a legitimate administrative function of a inventory search, is to make sure that a arrestee is not bringing to the jail any sort of item that could harm either himself or other inmates.
Can I ask you a question that confused me when I was reading the briefs and I realized I don't think I know the answer to this? So the question of when a person is actually placed under arrest, not when the officer decides to place him under arrest, but when you are arrested. Now, your friend on the other side suggests that there may be some cases that suggest that that's a factual question reviewed for clear error, but then I'm thinking about like Ornelas and all the cases that come after Ornelas, like when are you in Miranda custody, when is there reasonable suspicion, when is there probable cause? And the court has said all those questions are questions of law subject to de novo review. So is the question of when a person is actually under arrest a question of fact or a question of law?
Judge Heitens, I don't have.
Or what is the standard of review for an appellate court reviewing a district court decision about when the moment that a person is actually under arrest?
Judge Heitens, here's what I will say is, coming into this argument, I believe that it was a factual question. That very well may be because that's the way it was represented in the briefs and it wasn't thoroughly issued.
Right.
However, as you know.
Because I know whether someone's in Miranda custody is definitely de novo.
Sure.
So then it would seem to me that whether a person's under arrest is also probably de novo. Now, with the gloss that all, like, obviously, if the district court makes factual findings about what actually happened in the world, those are all clear error.
Correct.
But the question of whether those facts all add up to, and at that moment, a Fourth Amendment seizure that we call an arrest has taken place.
I certainly understand that line of thinking, but I go back to the fact that under this court's decision in C,
No, I think it's a moderately friendly, helpful question because it might then suggest that what an officer says about when a person was actually under arrest may not be determinative or even particularly relevant.
Exactly, that's the point I was about to make, is that the critical inquiry or analysis focuses on, at least in this context, when the officer would have arrested the subject, and here the testimony on that point is rather clear. I'm happy to answer any other questions that the panel may have. Otherwise, we'd ask that you affirm the district court's opinion.
Good.
I have no questions either.
Thank you.
Thank you. Mr. Neely?
Thank you, Your Honor. Just alleviate any concern that Judge King may have or the rest of the panel members may have, just wanted to direct this court's attention to this court's decision in Alston from 2019. And again, discovery is not inevitable unless the government proves that police not only could have lawfully obtained the evidence, but also would have done so. So could and would do in fact matter, Your Honor. I just wanted to make sure that was clear. In terms of, and of course I talked about a couple Second Circuit cases. Those were Stokes and Heath, and those both talk about whether an officer could have arrested somebody is not the question. It's would that officer have arrested, and it actually is based on the officer's testimony. And as far as Judge Heighten's question about the standard of review in this case, I would agree that it is de novo legally when somebody is under arrest. Of course, the factual findings underpinning the scene of the arrest are reviewed for clear error.
Could, and I'm only one of three judges, could I be inclined on this evidence to think that this guy was under arrest when they approached him?
No, Your Honor. Officer Chinati made very clear that he was not under arrest.
I know what I'm talking about me. I'm talking about me from what I know. I'm from looking at this record.
Your Honor, I think.
Yeah, well, all right, and you'd say no there. How about when he said, I've got that's a little bit of weed?
I would say it's a Terry detention, Your Honor, and again, that's also a legal question this court reviews de novo.
They had, if that's had reason to arrest, then they had reason to search him protectively. They had to protect themselves and the public. They had to protect the public because they knew that he was extremely dangerous.
Well, Your Honor, that would be a search incident to arrest. Those are the criteria for a search incident to arrest.
A protective arrest,
And,
protective search.
and the district court said this was not a,
If you find a firearm in a protective search, it's certainly admissible in evidence and entitled to be prosecuted.
the only way to do that would be,
We're talking about hypotheticals.
Yeah,
We gotta
that-
deal with facts, as Judge Wilkinson said, and the facts are what the facts are.
yes, the only two scenarios
And the
I,
judge ruled on the inventory search and was inevitable the discovery, and that's a theory too that fits. I think about any way you look at it here, your fellow's in a mess.
he's in a mess
Which
because.
he knew that right at the time.
He's in a mess because the officer violated the Fourth Amendment and unlawfully searched his bag. And only then, based on the evidence found in that bag,
I'd commend the officer.
Can I ask you just how the BOLO lays into this? I will say, like, look, I think we can probably say as a descriptive matter, I mean, I literally stayed in a hotel room last night that had a warning that said, don't smoke marijuana in this hotel room. So, like, notwithstanding the fact that marijuana is still legal as a matter of federal law, I think every police officer in the world knows that lots and lots of people are using marijuana in violation of some state and federal laws. So, but the BOLO, right? Like, so in asking the question, would this officer have arrested a person for having just a little weed? I was like, I mean, in general, maybe not, but like a person that was the subject of a BOLO about armed robberies, yeah, I think an officer probably would arrest that person for having just a little bit of weed, don't you? Doesn't that seem extremely plausible?
Your Honor, again, we're dealing with speculation, which in Nix v. Williams in footnote 5, the Supreme Court says we were looking at demonstrated historical facts, not speculative elements.
Sure, but I guess in terms of determining whether the district court's factual finding that the officer would absolutely have arrested him the moment the officer heard the words "just a little weed," it feels like the BOLO is relevant context in terms of the plausibility of the officer's claim. I definitely would have arrested him once I heard these words.
I think the BOLO goes to the initial Terry investigative detention. That's the relevance of the BOLO. That's why the government
I
offered
could
it.
easily imagine an officer on the scene saying, "Thank you, you've just given me an excuse to arrest you," which is something I would have liked to do anyway, given the BOLO.
Well, Your Honor, again, the temporal sequence is what's important. And say that's, obviously, as I discussed, the defendant's companion was already going to be arrested for the drug paraphernalia. The officers not only determined they had probable cause, they determined they were going to arrest Devin Bracey for the possession of the drug paraphernalia. And in terms of, I just wanted to quickly address the Peterson case that the government filed in the Rule 28J letter. That case is no different than say, that was a defendant who had misdemeanor warrants, but then during the arrest scene resisted arrest, which was a felony, and therefore they were going to arrest him anyway, not for anything they found. And Your Honor, we would just ask that this court reverse the district court suppression ruling and vacate Mr. Wilder's conviction.
Thank you, counsel.
Are you appointed?
Yes, Your Honor.
That wasn't on our papers. We didn't have it.
I didn't see, you were court-appointed?
I'm a federal public defender. I represented Mr. Wilder from his
okay.
arraignment through today.
Whatever your status is, we thank you.
Thank you, thank you. Yes. I'm an AFPD, yes.
And you too, sir. We'll adjourn court and come down and greet counsel.
This honorable court stands adjourned. Sine die. God save the United States and this honorable court.